All right, Paul Sponcia, CEO of the IT company, working in the comfort of my home under COVID-19 pandemic stay-at-home orders, as all of us. And I'm here with my friend and my attorney, from a business perspective, John Wood. And I'm going to let you tell everybody who you are and who the firm is and kind of what your specialty is, and et cetera.
Okay. Yeah, my name's John Wood. I'm with Egerton McAfee here in Knoxville, Tennessee, and we are a general purpose law firm that represents businesses like Paul's in all types of matters, from litigation to transactional matters. My background is specifically in software. I have an undergrad and master's in computer science. I worked for an extended period of time in the software industry before I went to law school. And so my practice has focused around assisting technology companies, software companies, and then with licensing issues, software, technology, do a lot of trademark work, copyright work, those types of things. And also general business work as well.
What if force majeure is not explicitly listed in a contract?
So there are statutory provisions that essentially provide the same thing in some cases. So all sales of goods are governed by a statutory provision called the Uniform Commercial Code,
okay,
which is adopted in every state. And the Uniform Commercial Code built in has a provision, it's UCC 2615, excuse by failure of presupposed conditions. So, and again, this only applies to goods. So in other words, if you were under contract to provide a certain number of goods by a certain date and sell them at a certain price, and all of a sudden your factory closes and you don't have a force majeure clause, you probably can rely on this UCC clause, which says delay in delivery or non-delivery in whole or in part by a seller who complies with paragraphs B and C is not a breach of his duty under a contract for sale if performance as agreed has been made impracticable by the occurrence of a contingency, which was a basic assumption on which the contract was made. And so a basic assumption would be that I'm allowed to operate my factory whenever I want to operate my factory, right?
Yeah.
There was no basic assumption that neither party assumed that, in March of 2020, my business was going to have to shut down and I wouldn't be able to make my widgets, right? So if you have a contract, so even if you don't have a force majeure clause, if you're selling goods, you may have some statutory help. And then in some states, it's also built in just the general civil code, which would go beyond goods. So California has a statute that excuses performance prevented or delayed by an irresistible superhuman cause.
Wow. I love it.
Right? Yeah. So this would be Avengers kind of stuff, right? Yeah. So if the aliens come in, but I think a pandemic, forced closure by the government would potentially apply there. Yeah. So even if you don't have a force majeure clause in a contractual remedy, you may have a statutory remedy.
What if you have a contractual remedy that's not as good as the statute, meaning which one supersedes? Like if I have one that is very pro the opposite, but I'm the one being suffering as a result of it, does the statute pick up, or is it no, whatever's in your contract kind of supersedes it?
Well, if they conflict, then your contract may govern.
Got it.
But a lot of times what you'll have is a one-sided force majeure clause, and then the statute may help the other party.
Okay.
Yeah,
right.
It's really what you would have. So I think there's some relief even if you don't potentially have a force majeure clause. Right. And another thing I want to point out about force majeure clauses is it's hard. I mean, a few force majeure clauses had epidemic or pandemic listed in them. I think yours actually does, Paul. So
I'll have a good lawyer.
Yeah. But it's hard to foresee every potential thing that's going to come down the road, and so foreseeability is a big deal, because usually it says or any unforeseen event.
Yeah.
So one thing people need to keep in mind is that this year, COVID-19, a pandemic, is an unforeseen event. Next year, it probably isn't.
Yeah.
Right. Yeah. So if you enter into a contract next year, everyone should adjust their force majeure clauses to include pandemic, epidemic, closure by the government, the things that have happened this year.
That was going to be my question. So you're an attorney. People are going to be coming to you and saying, "Hey, this happened." Everybody, once we get through whatever is next, whatever that looks like, people are saying back to normal. I don't think we're ever going to be back to whatever, just a new normal. I think good businesses, I'm in this case of thinking through this, are going to think back through and say, all right, so we went through it. I need to update my policies and procedures. I got to go reevaluate my crisis management and, all these different continuity of operations.
Right.
One of those things is going to be contracts, and this is going to be an area where people are going to want to pay a lot of attention. So what do you think do you think anything substantial will change in that as you go advise people?
I think people are going to look at their leases a lot more carefully, and the clause that says, the landlord is excused from everything based on a force majeure clause, and the tenant always has to pay. People may start to negotiate that a little bit harder.
Yeah.
And then even any kind of service business where you've got to deliver a service. I mean, what if you have to shut down and you can't deliver your service, or you can't get into the building to deliver the service?
Yeah.
How people weren't thinking about that before. I think some lawyers were.
Yeah.
Business owners weren't.
Yeah.
They didn't think it was important because it would never happen, because it's never happened to them. Now all of a sudden they're like, well, what if I actually can't perform under this contract? How are we going to allocate the liability?